Wow.
Okay.
Right? Wow. Obviously, I think, sort of Nico LaHood did a great job. What I think stood out for me about him is that he systematically went through the case and pulled out sort of all of the pieces of testimony, all of the relevant facts, all of the timeline that directly attacked their indictment.
Right.
Right? And I think that that's, sometimes in the emotion of everything, we lose sight of the fact that criminal law is element-based.
Right. It's elements of the offense.
Elements of the offense, you have to prove each and every element beyond a reasonable doubt. And so he systematically took the state's case and said, doesn't do this. He did act. He didn't fail to act. And then I thought it was super effective that he did the comparison between the other people that they didn't charge.
Salcedo, Coronado, Randy
Mendoza.
Hill, all these guys walking step by step what they did or didn't do, what they had access to, what they didn't have access to.
Right? I mean, I think that was really, really effective because it feels like their whole theme was he did act. Maybe, and I think, Tanya, you put it best. You said, maybe we don't like how he acted or specifically in what manner, but the point is that he did, and the charge is that he didn't.
Mm-hmm.
So I think we fall flat right there. Okay, and so now we have the elected that did the close for the state of Texas, and I think they missed the mark. Right? I think that, sort of you and I were talking about the fact that this case should have been very precisely about the elements of the offense that Adrian Gonzales was facing, not about all of the other, how many shell case. None of that really had, they could have really potentially presented a really, really straightforward case about whatever was specific to Adrian Gonzales. And I think that they missed the mark on that. And I think that her closing argument, didn't do it either.
And folks, I want to apologize for my voice. The allergies has taken it away. And so we have Bree West today as our legal expert. And again, I'm Tanya Iser. Normally my voice is much better, but not today.
We get glimpses. We get a little glimpse of
it comes
Tanya.
up and down, yeah. I thought, what did you think about, you mentioned when the first thing she told the jury was that the judge was going to do punishment, and you made a remark about that. And I want you to talk a little bit about that.
So from my perspective, that was highly inappropriate, right? During jury selection, you don't even, if you're not going to a jury for punishment, you don't even qualify them on punishment, right? Because you say to yourself, it's not even something that you have to do. They're told that in jury selection. I thought it was incredibly inappropriate that the state of Texas or the prosecution got up and said, oh, FYI, you guys aren't going to have to worry about punishment. That was just a totally inappropriate comment to come from, a little bit beneath the dignity of the state of Texas. It wasn't, that's just not something that's done in a criminal trial.
It's like, if you'll find him guilty, you don't have to figure out what he gets.
Right. And it's just, no, that's not, that's kind of not what we do. I think that just stand on your case. I get it. This is a hard case for the state of Texas. I think that the facts are really difficult, and they're in a lot of ways not there, and so they're grasping at straws. But stand on your case. You decided to bring it, right? So don't have all of these other sort of ancillary. Oh, you don't have to worry about punishment when you find it. Yeah, all of that is just highly inappropriate in my opinion.
What do you think was the most effective thing that the defense did in their arguments?
Gosh, the most. Mm-hmm. I think that's. I think that both defense attorneys, they split their time, and both of them had a different style that I think had highlights, right? So I think that one of the things with the second attorney, Nico LaHood, is that he brought everything back to, I'm a real person that exists in the same communities that you live in. My kids go to school too.
Right.
And so the outrage, the sadness, the fear, everything that you have, I feel it too. So understand that where I'm coming from is from a human place, right? And so what I'm asking you to do in finding my client not guilty is not insane, right? Because I could do it too if I were sitting in your place. And so I think that was super effective to remind them that this is not sterile. This is, this is real. And then, he did some of the standard defense attorney things, right? Like, hey, if you didn't like how I questioned somebody, hold that against me. Don't hold it against my client. And I think that was important, because I think that there were some people that thought he was a little bit aggressive. And so I think that was I thought that was really good. But I think that the biggest thing with him in particular is that you were captivated by how he was telling the story.
Right.
And I think that made a gigantic difference if you just compare the two sides.
And my sense is always with trials that trials really are storytelling.
Yes.
And you have to tell a story.
And, we talk about this sort of in criminal justice, like who do you like more? Who tells the better story? Right? And I think that has a huge impact on the way that a case comes out. Because, I've had juries after the fact come to me and just say, I hated you. I hated how you did this, or I hated how you did that. And so most of the time I come in second, right? So how are you presenting to the jury? Are you connecting with them? I think the defense did a really good job with that.
Now, was there anything in the prosecution's side that you thought was effective?
I think that I think that they made a decision to bring a case that really is very difficult to support with the evidence that they have. So do I think that they did a good job with what they decided to do? I think the prosecutor, the elected DA that did the close, I think that she did what she could, right? I do think that she was much more pinpointed. You could follow kind of what she was saying. I understood she was making global, public policy type of arguments, and, all of that kind of thing. And I think that was, with what they were doing, that was probably as effective as she could be.
Because it is a very difficult case, because it is an unusual case. Now, if Adrian Gonzales is found guilty, okay, so if he's found guilty, what happens next? Walk us through what people could expect to see next.
So if he's found guilty, obviously that's kind of where the jury's job ends, right? So the very first thing that will happen is that the judge will release the jury, thank them for their service, because there's no part of the next punishment phase that they'll have anything to do with. And so, but then the state and the defense go into a punishment trial. Now, whether or not that would happen today, it could be that everybody kind of just needs a little bit of a break if they were to come back with a verdict today. And so they may reconvene and regroup tomorrow. But essentially, both the prosecution and the defense would put on a full-blown punishment trial where you bring out everything that you want to. It goes in the same fashion as the jury trial, right? Prosecution goes first, they rest their case. There's opening statements.
The whole 9 yards.
There's closing arguments, right? Because everybody, you're still advocating, right, for your side, even if it's to a judge. Now, obviously, there are other circumstances where, say, the prosecution and the defense could come together and say, hey, listen, we as the state of Texas were satisfied. Do you want to reach an agreement on punishment if he were to be found guilty? That could happen too. If that's the case, then they would present that agreement to the judge to say, hey, will you accept this? And kind of save us all a little bit of time. So there's a couple of different ways that it could go, but regardless, the jury will be released and actually invited. The jury can then come into the courtroom.
Oh, really?
They're released from all of their instructions, and they can come and listen to the punishment case. They can talk about the case. They could give interview. They can do all of the things once they're released. So,
I do have to, before we forget about it, we had Abraham Lincoln.
Yeah.
Thomas Jefferson.
Abraham Lincoln, Thomas Jefferson.
What'd you think about that?
I was now I have to say Lady Justice was great, but I thought in my mind I thought that the defense absolutely pivoted on their feet to bring our response to Abe Lincoln. I that had to have been like, I think they Googled as they were sitting there to find a good quote. I thought it was hilarious, but. The Lady Justice, that was a lot of time spent on kind of what the role is of the criminal justice system and the role of jurors in the criminal justice system. I thought that was, we had arrows, we had a definition of the blindfold and the sword and
their ability to like change on the fly.
Right. I think is the markings of a really great defense attorney. But I think that I loved sort of the way that they have played off of the prosecution, the way that the defense has played off the prosecution has been nothing short of just, are there Grammys? Are there awards given? I mean, other than a not guilty or given out?
Okay, I don't think so. You've been a prosecutor.
I know. I mean, but this has been pretty outstanding. I mean, it has really been I think you said it. It's been a master class in how to try a case from a defense perspective.
Oh yeah. I mean, I've watched many trials in my career, and I have seen, and this is they definitely have done an amazing job.
I think so too. I think so too.
And obviously a jury, they could talk to people about just what happens when jurors go back into that room. What happens? How does that go?
So, obviously, as much as I wish I could be chosen to sit on a jury, that's my dream. Mm-hmm. Nobody would ever pick me. I mean,
nobody would ever pick me.
Nobody would ever pick us. I think we would be really good, though. I think so.
I can look at the facts and evidence.
I think I could do that, unbiasedly. But so ultimately, you go back there. Most of the time, what happens is they sort of immediately pick a foreman, right? They need some kind of leader. They need somebody that's going to say, okay, when we want to take a break and sending out notes and what evidence do we want. And so I think they generally will pick their foreman. Most juries then at that point, they go through the charge, right? Because they want to be reminded of what are we actually supposed to be deciding here?
Right.
We just heard, 3.5, 4 hours worth of closing arguments. We also had 9 days of testimony. Right? We need to just be reminded of what we're supposed to be doing. And so then once they do that, they start talking. A lot of times people take polls. The ultimate verdict is never going to be a poll, mm-hmm. right? The ultimate verdict is never going to be by chance or lot. But most of the time, mm-hmm. they start by just saying, okay, where does everybody stand? What do you guys think? And I've seen verdicts come back almost instantly based on the fact that they didn't really have to have any discussion because everybody was on the same page.
Do you think that could happen in this case?
I think that what is likely to happen in this case, even if they go back there and they say we're all on the same page, out of respect for all sides, I don't know that they would come back as quickly as I think a lot of us think the verdict would come.
Well, I mean, and I would not find it unusual if they come back tomorrow morning.
I think we're on the same page about that. I mean, the over-under on them reaching a verdict today but not announcing it until tomorrow, in my book, is really high.
Okay. For folks that might just be tuning in,
okay,
and I'm going to let you do this since my voice is really bad. Can you give folks the quick, 5-minute rundown, 3-minute rundown of what just happened over the last 3 hours?
Okay. So today we came in. It was already decided and announced that we were going to do closing arguments. The things that were decided were the length of time that the state and the prosecution were going to be able to have in closing arguments. There were some last-minute things that were going to be decided before closing arguments began, which I think, Tanya, happened off camera because they came in and the jury was walking in, but we also know that we were delayed. So we're not 100% sure about what that might have been. But what initially happens is that the judge reads the charge of the court, which is, hey, jury, this is now what you're charged to do, right? You have to make a decision on these 29 counts as it relates to Adrian Gonzales's guilt or not guilt. And then once the judge reads that, we immediately go into the closing argument. So the way that closing arguments work in the state of Texas is the prosecution gets to open the argument, which is what we call the open to the close. Mm-hmm. Sandwiched in between that is the entire closing argument of the defense. So the defense doesn't get to break it up other than between people. They don't get, they don't get to go again after the after the prosecution goes or anything like that. And so sandwiched in between there is our closing argument, which we got to see our, I'm going to say defense attorney gold. I mean, it was really outstanding. And then the prosecution goes and closes the argument, closes the case. That's what we call the close. So what we saw was the prosecution opening the closing arguments, defense going. We did have a break, which we talked about that. We said there's got to be a break. This is going to be 3.5 hours, 4 hours worth of just argument. So we had a little bit of break in the middle of the defense argument, which I thought was not terrible. I mean, I gave them a minute to regroup, and I thought they came back really strong. And then we had the final closing argument of the prosecution, and jury is now sent back to deliberate. It was as smooth can be in terms of how we deal. There were a lot of objections on the part of the prosecution in the middle of the defense closing argument, which I think in some ways is a little bit unusual, right? I don't know that we often see, if you're sort of secure and strong in your facts and in your case as a prosecutor, I don't know that you have to object a whole lot during the closing argument. It's not evidence. It's just the summation of the argument.
Okay, so I'm going to ask you to sum up the prosecution.
Oh my God. Can I? I mean,
Try.
I don't, okay, I'm going to try. I think that in a weird way, I think that the first part of the prosecution's argument was sort of a KISS type of style, right? Just keep it simple. They had 3 points that they were trying to make as it relates to why Adrian Gonzales should be found guilty. He had the training, he didn't use the training, the children were in imminent danger, and he failed to act, right? Those are, and they felt like they didn't even need to go into a whole lot of detail about those 3 points, but literally during the first part of their closing argument, those are the 3 points. They said, this is what our case is about. I mean, I think we can all sit here and say that we watched 9 days of trial, and it was really, that's not what you made your case about.
Right.
But that's what they said. And then they, make their public policy arguments. But then in the beginning of the state's closing argument, they spend like more than half of their time talking about what they think the defense is going to say, as opposed to just saying, this is our case, these are our facts, this is what we're going to talk about. They spend more than half of their time. So they talked about he had the training, he failed to act, and the children were in imminent danger. That's it. And then in their close, the elected DA, the prosecutor, said, we can't let, children die in vain. That was like the ending of her argument. And I sort of said, nothing about what you guys said was what you presented during your case. I mean, yeah, we heard a little bit about training, but we really heard about the emotional aspect that this had on the people that lived it.
Right.
And I don't know that that's kind of the relevant parts of a criminal trial. So the summation of their argument is, I think, even though they didn't present it during the actual trial this way, that Adrian Gonzales had special training. Adrian Gonzales had special duties as it relates to the children. Adrian Gonzales knew what was going on. Adrian Gonzales failed to act, and Adrian Gonzales failed to protect and save those children.
Okay, so we've got Rebecca Lopez on the line. And so, Rebecca?
Yeah, Tanya. Well, obviously, the closing arguments I thought were very powerful on the part of the defense attorneys. And I felt like, and I agree with our expert, that it didn't feel like the prosecution wrapped everything up in a bow and handed it to the jury like what they started with in opening statements and then in their closing arguments and then their witnesses and the testimony throughout the trial. I felt like they didn't kind of wrap it all up and hand it to the jury in a concise way that they could possibly render a verdict of guilty. Yeah, that's just my opinion from listening to all and then listening to all the experts. And I also thought it was really interesting. I've never seen, and Tanya, maybe you have, I've never seen a defense attorney play recorded opening statements of the prosecution back in court and said, this is what they told you. And they didn't prove this. I thought that was very effective. I've never in my career, and I've covered a ton of trials, I've never seen them come back and play the prosecution's own words back in the courtroom in their opening statements to the jury. And I thought that was very powerful.
Yeah, Bree, go ahead.
Yes, Rebecca, I have called that a boss move. I mean, it was phenomenal. In all of my years, have never seen them be able to pivot. And that's kind of what Tanya and I were talking about. They are pivoting, that defense team is pivoting on their toes in a way that I don't know that I've ever seen. And I think that was a very powerful example of that.
Absolutely. Go ahead.
Yeah, and then I thought also the way that, I thought also the way that they outlined, they're telling you that he had to do this, and then that whole laundry list. And they said, if you've got one doubt about any of these things, then you have to render a verdict of not guilty. I thought that was powerful. And then obviously, I thought that to me, a very powerful thing that the defense did was compare what Coronado, Mendoza, and Salcedo did versus what Adrian Gonzales did. Because if you do look at the actions of the officers, they're like, why is he sitting in this chair and these other officers aren't? Because they didn't go towards the action. They stopped and they set up a perimeter. And the video of them crouched behind the vehicle, and then the video of Salcedo training his weapon on what appears to be the shooter and not firing that shot, I think sit with the jury, because there were other officers out there that possibly could have stopped this tragedy, whereas Adrian Gonzales was on the other side and didn't see it. Now, maybe they thought, well, he should have run around the school and try to find the gunfire. But if you've got 3 officers and one with an AR-15 that's actually had his weapon trained on the shooter, and you don't take that shot, to me, I feel like that leaves a little bit of doubt for the jury, or a lot of doubt for the jury.
Yeah, I was going to say a lot. I think that is exactly sort of the crux of where things are. Why is Adrian Gonzales the one that's sitting in this seat? Look at what these other 3 officers, what they were able to do, or how they were positioned, versus the person that's sitting here was literally on the opposite side of the building. I mean, if that doesn't raise reasonable doubt as it relates to Adrian Gonzales's guilt with what they've charged him with and how they've charged him, then I don't know what would. I really don't.
Well, and one of the things that they said in opening statements that they were going to show this jury is that Adrian Gonzales sat around and did nothing. He just basically stood by his car and didn't do anything. But the defense, I thought, was very good in showing, or very effective, I should say, in showing the jury, well, but he didn't just stand there. He's dealing with this frantic witness. Doesn't for sure know at this point, there's a car crash. He thinks it might be a bailout initially. He's trying to figure out what's going on. He does call for cover, which is what they're trained to do. And then within 30 seconds, he's got a backup officer, and they enter the school. They get shot at. They go into that fatal funnel. And but when you heard the opening statements and when they spoke to the jury during voir dire, it made it seem like Adrian Gonzales just stood around and twiddled his thumbs and didn't do anything at all. And I just don't think that that's what actually occurred. So it's an uphill battle, I think, for prosecution to get a guilty verdict here.
I couldn't agree more. I mean, I think that this is rough for the prosecution.
It's definitely a tough one. Rebecca, do we expect the families to come out today? Do we expect the families to come out?
Yes. I don't think the families are all kind of in the courtroom, and some of them went to go grab a quick lunch. Obviously, they're going to give the jury lunch, and they're going to deliberate during the lunch hour. But the families are expected, if there is a verdict today, they are going to set up a podium, and the families are all going to come out together and speak. Mm-hmm. And also, if there is an acquittal, Adrian Gonzales and his defense team are going to come out, and Adrian is expected to say something. Now, I think that he's very tormented also about what to say, because he does realize that these families have lost their loved ones. They've lost their children. They've lost their teachers, their sisters, and so they're, just, it's very difficult for these families. So I think that they're mindful of that, the defense attorneys, on if he is acquitted, what Adrian Gonzales should say that doesn't come off as, oh, woe is me, I was the victim here, because clearly the victims in this shooting were the 19 children and the 2 teachers that died and the 10 children that got injured. And then the impact and the effect that this had on an entire community, their families, their friends, on really all of us that felt the pain of these families. And so I think that they're going to be conscientious that when and if he is acquitted, that he will then come out and say something with his defense team.
Well, there really are no winners here.
There are no winners here, and I think probably what I would anticipate, if you'll remember the defense attorney that opened their closing arguments, he finished his portion by saying, you know, these victims are not honored with an injustice committed in their name, right? And I think that that's a really probably powerful way to have Adrian Gonzales, if he's acquitted, say something and not make himself the victim and not sort of take attention away from the families that have lost here.
And what did you make of the fact that you had both sides saying you need to send a message to law enforcement? One side saying if you find him guilty, the message is, well, you should just sit back and do nothing and don't go in, and you're going to be sitting here where Adrian Gonzales is sitting. So that's going to give officers a second thoughts about, you know, acting right away. And then you've got prosecutors saying, well, you need to send them a message because they're going to be held accountable if they don't go into that school. So it's just such a two different ways of looking at things. And I'll just be curious. I'd love to talk to the jurors after this to find out when they reach their verdict, what persuaded them one way or the other.
I think that would be really interesting to hear from them directly. I think from my perspective, we're human. And I don't know that there's, you know, the majority of humans don't view themselves as perfect. And I thought that it was really effective for the defense to say what you would be saying to police officers, to school police officers, is you have to literally be perfect. And if you're not, and if you don't do everything right, and if you don't make every right decision in the moment, then you're going to be held criminally responsible for being an imperfect human being. And I thought that was more effective because I think that all jurors, all people could put themselves in the shoes of somebody to say, man, I've certainly been in circumstances where I've not made, you know, the best decision. I did the best that I could with what I had or knew. And so I think that was way more effective than sort of almost berating the jury to say, you know, you better hold them accountable and they better go in that school and they better, you know, sort of die in that, you know, fatal fun. You know, I just think that's, I don't know that humanity is going to support that standard.